It seems what you have said, Barrister, and what Barrister Festus KEYAMO said is totally different from what the lawyer who just spoke a few minutes ago is saying, that the National Working Committee led by May Manabuni, let me just say the caretaker committee chairman of the party, his position remains sacrosanct and it has nothing to do with any judgment. So what do you think?
Well, let me start with this, that I will not be ready to join issues with the NANESIC, particularly as it comes to the judgment of the court yesterday. Because God forbid that I should constitute myself as an appeal or to review what is so clearly meant to the whole world, particularly about the issue. But as it is, and from the pronouncement of the court yesterday, we can see clearly that though we may call it minority judgment, but there are many times that arbiter of the courts, that is by the side, can really give a pointer. And like I need to say this, and I clearly said it, that what was said yesterday, it is like a word of caution. And it is now left for the PDP, for the APC, to take that words of caution. And that is why I made that position as it is. It is so clear that the continuous staying of Malabuni as the interim chairman of APC is clearly a legal liability to the party. Legal liability that, because you can see that the learned jurists, they raised the issue that Malabuni should have been joined, and Adibeda has been joined, then the merit of the issue will have been reviewed. And finally, the minority judgment, the exhibit P21, which is the nomination form, was set aside. Now the question is this: had it been that Malabuni is joined, we know what will have happened. And again, let us look at it from this point. Irrespective of what is said in the court yesterday, the question here is this: the Electoral Act has stated it, that for you to represent the party, for you to be someone that will nominate, must be an elected official. And it beats some of us, Olo, today to see that APC, some section in APC are canvassing for unelected persons to govern the affairs of the party. Now, the question which you're asking is this: an elected person trying to superintend a democratic process, and you think it's as like one of my senior mentioned it today, it's as if I've been bringing a military personnel or bringing an elected person to superintend and to administer a political party. And you can see how low we have gone. And that is the issue. It is more or less an opinion, but opinion backed by the issue of the law. I know the learned sick mentioned that somebody is not in court or not, but by the time we check very well, you find out that colleagues were in court, and we have the report. And if what I'm saying is what it is, that what should the question is not whether somebody is in court or not.
Okay, now let's even leave whether the person is in court or not. Let's take a look at what is written in section 183 of the 1999 Constitution as amended, as well as what is even in the APC Constitution. So if May Malambuli's position has been on for over a year now, and in the APC Constitution, it says the caretaker committee will stay for 6 months and they conduct a national convention, and that seemed not to be the position. So it's like the party itself, it's operating illegally against the Constitution of the 1999 Constitution of the Federal Republic of Nigeria, as well as its own constitution. So what's the implication of this?
The implication is it is as rightly pointed out yesterday, in my opinion, that whosoever that queried that position, of course, whosoever and whatsoever that is done by the same ESCO, which is non-elected, not only that, the sitting governor, in violation of the position of the Constitution, is superintending the party. Whatsoever that has been done can be set aside by the court. And yesterday, the Supreme Court gave a pointer to that. And that is a very simple thing. I know many people will continue to say, after all, we have some governors who are chairmen of their respective governors forum, forgetting that it is like the same thing that today we have some governors can be the visitor. All those ones are not executive office. The constitution is so clear on what you should not do. It is the word you shall not. Executive office. Being a visitor of a university is not an executive office. It's like a ceremonial head. Being the chairman of governors forum is not an executive position. That is why they have director general of governors forum. But we are talking of executive office. If care is not taken, the governors today will be canvassing that they have to be made as the vice chancellor of a university. The governor tomorrow may say they want to be the executive secretary of the National Union of Road Transport Workers and all that. Whereas that is not what it is. And we should ask ourselves one question. How manage out of 200 million Nigeria, can't we have somebody who is competent to be elected? The question is to be elected to superintend the political party. It is only in Nigeria, and I must say this, maybe PDP, where we are having that the unelected personnel, and we have lawyers canvassing for that they should be the one that should superintend. And like I said, we have courts in this country, and the court will do justice, but I think we need to raise such alarm to let them know that whatsoever that such personnel, such group do, certainly will be set aside at the right time.
Okay. Thank you very much, Barrister Kayode Ajulo, for your time. I know I told you that I'll be taking you for just a few minutes. I appreciate your time.
Thank you.
Also appreciate your comment. Thank you very much. So let's come to the studio. And here in the studio, we also have a lawyer. I have Barrister Ilemuna Onoja with us here. Thank you for coming on the show.
Thank you for having me.
Once again. You've listened to Barrister Kayode Ajulo and his position. He's even a member of the party. And he has said whatever they are doing, they should take precaution. So what do you think? Let's look at the minority judgment as well as the Constitution 183.
I'm looking at, first of all, like he rightly said, it is not in my place to presume to sit in review of a judgment of the Supreme Court. It was the late Justice Chukwudi Puta who said in one of his very erudite judgments, we are not final. He was speaking about the Supreme Court. We are not final because we are infallible. Rather, we are infallible because we are final. There must be an end to litigation, right? But we can, for the purposes of enriching our legal jurisprudence, speak about, for the purposes of education, speak about the judgments of our courts. And it appears to me that in the conclusion, there's curiosity there. There's basis to be curious. In the Court of Appeal, 5 issues were formulated for determination by the Court of Appeal. The issue of Mai Mala Buni being a governor of a state and therefore incapable by virtue of Section 183 of holding another executive office was only one of those 5 issues. That issue was formulated was determined in favor of the PDP. It was. The conclusion is we agree that this ought not to happen. However, because you didn't join him to this suit, we cannot cut a man's hair in his absence, and therefore it is fatal, which formed the basis of the appeal to the Supreme Court. One of the issues formulated for determination. Now, on getting to the Supreme Court, in addition to this issue of holding executive office, by virtue of Section 183, another issue came up, whether the non-joinder of Mai Mala Buni was fatal to the appeal. That's the issue and the Supreme Court found in favor of the APC. I'll come there now. But we haven't needed a decision of the Supreme Court at any point in time to know that what is going on is unconstitutional. We don't need that.
Going on within
the APC. We don't need that. It's very clear. The words of Section 183 are clear, unambiguous. He shall not. When there is in statutory interpretation, where the word shall is used, you should know that it invokes an obligation. It is compulsory. You shall not hold another executive office. He's holding an executive office. Now, it is in UAC versus McFoy where the courts held that once something is bad, it is incurably bad. At the foundation of that, it poisons everything else. So, having nominated Rotimi AKEREDOLU as the candidate of the APC is one illegality to another. You cannot put something on nothing. It cannot stand. It will fall. There's nothing there. Right? The basis, the foundation of that nomination is that you're chairman of the APC. That office you're holding unconstitutionally. The Supreme Court did not determine that issue. What the Supreme Court said, because he was not before us, this issue cannot be determined. It raises a question in the mind of jurists or of lawyers at all levels. It raises a question. The question being, having added his political party as a party, must you separately add its acting chairman? If we follow many decisions of the Supreme Court in a plethora of cases, it really must not be so. The Supreme Court has held repeatedly, for instance, that if you add INEC as a party, you don't need to add the INEC chairman. You don't need to add a resident electoral commissioner unless there is a specific allegation of the commission of a crime. There's no such allegation here. What the PDP has only simply said is, this is unconstitutional. Now, not only is it unconstitutional, and the Constitution is the biggest law in our land, it's the most fundamental, foundational law of our country. But even by your constitution in the APC, it says that you cannot hold an executive office. An elected official cannot hold an executive office within the party.
But let's look at
it's very straightforward. We don't need the judgments of the court. What is happening, what you're seeing happen, is the willful disrespect and disregard of our laws by a group of people.
But let's also look at how this can affect the Anambra polls. Because we know that for you to submit the name of candidate, it has to be either the national chairman of the party or the national secretary. In this case of the APC in Anambra, would you say that the candidate of the APC in Anambra is there on illegal grounds?
It's unconstitutional.
What about if it's the national secretary that submitted the name?
Who is the national secretary of the APC? Is he not another governor?
Another governor.
Straight away, what we have is just a roll-up of a activity. It's not valid. That presentation before that submission before INEC, that submission of a nomination to INEC, ab initio, what the courts, listen, I hear what my learned senior, Mr. Ajulo, has said,
yes,
that this is obiter. But remember, in the majority judgments, the only issue, the issue of the basis upon which this case was dismissed, this appeal was dismissed, is that
he was not joined.
He was not joined. That's the basis upon which it was dismissed. The fundamentals, the merits, 3 justices of the Supreme Court and then justices at the Court of Appeal had already determined it in favor of the PDP. Let's not even forget that. Had determined that issue in favor of the PDP. We will see the fireworks that will come out of it, but it's very clear. We don't need, at this point, reading the provisions of the Constitution. And our courts have declared in a plethora of cases as well, that when you're doing statutory interpretation, read the words of the Constitution and give to it the literal meaning, the meaning that is there before you, unless it gives occasion to an absurdity. There's no absurdity here. It's a political commentator who wants to be critical will say that this is only evidence of the desire of powers that be within the APC to continually perpetuate an era of lawlessness, where there's no regard for the provisions of our law, where there's no regard for the decisions of our courts, and where people just carry on because they have power in any manner that they deem fit. Otherwise, it's clear ab initio. There was no need to even get to this point.
But let me also say, what about the case of INEC? what INEC did is to accept from the national chairman, the caretaker committee. Is it that they didn't know that Section 183 is there?
No,
and even
no,
in
no,
the
no, no.
even in the Electoral Act,
The Electoral Act and our laws.
and the laws, even the party
The Electoral
constitution.
Act and our laws have said that INEC has
Cannot.
no right to sit in judgment over its with regard to its receiving nominations. It's basically clerical. They have no right to determine what is right or what is wrong with nominations and internal processes conducted within the party. At best, what they can do is that if a suit is filed, they can go to court and give an opinion and say that we think that this was not done, or this was who did it, and we think that. But in terms of determining that they can reject an application, not only does the Electoral Act rob them of that power, our courts have also made several pronouncements to that effect. So there's nothing INEC can do.
So who then? That means, because I also heard that somebody from the PDP is going to court.
I'm unaware.
I heard it, that somebody from the PDP is going to court in Anambra on this same issue. And
the expectation,
if it happens,
the expectation is that, I mean, we should be able, our judiciary needs to stand up and do what is right. Our laws are very clear. The law in this regard is very clear. Stand up and do what is right. This is a poison chalice that poisons everything else. Do what is right. Remove the chalice. Take away the poison. What has happened, and I've spoken to a few people from the state who feel that, we have been an unjust and illegal, unconstitutional government has been foisted upon us based on a technicality. It ought not, this Governor AKEREDOLU, with due respect, ought not to have been an option in the elections. And so somebody who ought not to have been an option in the elections has been upheld as our governor. I've spoken to several people from the state who feel that way. Now, there will be a consideration, and this is a discussion that I've had with a couple of lawyers, taking into consideration Section 308 of the Constitution, which grants executive office holders immunity from proceedings before the court, unless they are nominal parties. Where then does the Supreme Court expect that the PDP should have added somebody who was granted immunity to an application, an appeal before it? It makes no sense. It's a conundrum. What we have in effect created, because in this matter, he wasn't a nominal party. The Supreme Court held that he's a necessary party to have been added to the appeal, to the entire suit in the first place, from the petition stage.
Would that, just like
Now,
you said, would that not be against the Constitution, adding a sitting governor?
Which is why the PDP there was no legal requirement for his addition. It does not exist. It doesn't exist. Having added the APC as a candidate, as a party to the suit, you didn't need to go and add its chairman separately, because there was no allegation of the commission of a crime against its chairman. This is elementary law. It was one of the first things we were taught in 200 level law of contract. It's very curious. It's a very curious judgment. Again, I must reiterate, I did not come here to sit in a capacity to review the judgment of the Lord Justices of the Supreme Court. It is not in my place to do that. It is not in any lawyer's place. Again, I must reiterate, Supreme Court, highest court in our land, the judgment is final, unless they agree to review it. But I came here to enrich the course of our legal jurisprudence.
All right.
This is a curious judgment.
Okay.
It's a very curious judgment.
So that means we'll be seeing more talks on this issue.
We expect that there will be more going forward. I'm very interested in seeing how Anambra pans out, because, again, like I said, 3 justices of the Supreme Court and the Court of Appeal have determined that issue in favor of the PDP. 3, that is a marker as to where this goes.
So what's the implication for the APC as it stands?
Personally, I can tell you that I think that from 1 year ago when he was sworn into office, his tenure was illegal. The APC,
as the caretaker
committee chairman.
So whatever he has done this
ought
1
not
year
to have had candidates in any elections thereafter where he signed the nomination forms. They ought not to have had that. I believe that from personal opinion, and my personal opinion is based very clearly on the very clear, very succinct words of the Constitution and the APC Constitution.
What about in the case of Nia Akintola-San, who says the case is a minority judgment, so nothing, it doesn't...
With due respect to his...
That the position of the national chairman is sacrosanct.
With due respect to Leonard SAN, with Leonard Silk, I did not come here to join issues, but for the purposes of clarification, again, the majority judgment did not determine that issue. Again, I did not come here to join issues, but that issue has not been settled one way or the other. The people who who settled it did so in the minority, on the one hand. On the other hand, it is also trite that a lot of times in our jurisprudence, fundamental principles of law are found in minority judgments or in obiter dictum. Obiter, like by the side,
yes.
Not the fundamentals, by the side. In some by the side pronouncements of the courts, you are able to formulate principles of law that are applicable throughout other scenarios. So dismissing a declaration of justice of the Supreme Court because they are in the minority, with due respect.